Case record. Shall we have submission by agent for respondent?
Monsieur le Président, honorable juge, le temps qui nous est imparti sera reparti comme tel. Napoulement dévie en 15 minutes sur les questions préliminaires. Daniel Marakourou en 15 minutes sur l'allégation A du fond. Martha Djekemei en 18 minutes sur les allégations A, autant pour moi sur les allégations B et C du fond. Et Rachid Tiemtouré en 15 minutes sur le D du fond.
Yes, proceed.
Je suis chargé de vous entretenir sur les questions préliminaires. Mes trois confrères s'entretiendront avec vous sur le fond de la défense. Avec une vingtaine de traités de droits de l'homme ratifiés, 6200 ordonnances de recommandation en faveur des plaignants et victimes de violations des droits de l'homme, sur plus de 7200 plaintes enregistrées. Tel est le modeste bilan dont peut se targuer Saint-Cyprien. En témoigne son prix Christophe Heinz Gold-Baxter. Monsieur le Président, éminent membre de la Cour, nous sommes au regret de vous annoncer que concernant votre compétence, vous souffrez d'une double incompétence en l'espèce matérielle et temporelle. Concernant la recevabilité de la requête, la partie défenderesse soulève des exceptions d'irrecevabilité. Premièrement, le non-épuisement des voies de recours internes. Deuxièmement, la non-introduction dans un délai raisonnable. D'abord,
So, agent, do you concede that we have jurisdiction in terms of all the various dimensions of jurisdiction?
can you repeat?
Do you concede we have all aspects of jurisdiction? To entertain this matter before we come to the admissibility.
Et est-ce que vous considérez que nous avons la compétence?
Pour ce qui est des 4 critères cumulatifs qui fondent la compétence de votre cour, à savoir le critère matériel, temporel, territorial et géographique, en l'espèce, vous êtes incompétent tant sur le plan matériel que temporel.
Encore faut-il le démontrer. Vous allez le faire?
Bien sûr.
D'accord.
D'abord, les exceptions d'incompétence. Primo, votre cour est rationnée matière incompétente. À la lumière des articles 3, 4 et 7 du protocole de Ouagadougou, votre cour est compétente pour connaître de tous les différends, de toutes les affaires relatives à l'interprétation de la charte, à l'interprétation et à l'application de la charte, du protocole et de tout autre instrument pertinent relatif aux droits de l'homme. Mais que faut-il entendre par instrument pertinent relatif aux droits de l'homme? Selon votre jurisprudence Action pour les droits de l'homme contre la Côte d'Ivoire, les conventions sur la corruption, sur la conservation de la nature et la Convention des Nations Unies sur les changements climatiques ne sont aucunement des instruments pertinents relatifs aux droits de l'homme. Par conséquent, des supposées allégations portant sur ces traités suscités ne rentrent aucunement dans le champ de votre compétence matérielle.
Excusez-moi, maître. Est-ce que vous pouvez nous citer les paragraphes précis de l'arrêt APDH contre Côte d'Ivoire qui mentionnent précisément que les conventions que vous venez de mentionner ne sont pas des traités de protection des droits de l'homme?
Ok, dans l'arrêt Action pour les droits de l'homme contre la Côte d'Ivoire, il n'est pas dit expressément que la convention, sur les conventions suscitées, ne sont pas des instruments pertinents relatifs aux droits de l'homme. Mais plutôt, il a été posé le principe de ce qu'il faut entendre par un instrument pertinent relatif aux droits de l'homme, qui, en son paragraphe de l'affaire, bien sûr, 57, fait ressortir que pour qu'on puisse qualifier un instrument pertinent relatif aux droits de l'homme, il faut se fonder sur l'objet, principalement sur son objet, qui soit cet instrument accorde des droits individuels ou collectifs, soit que cet instrument impose des obligations internationales aux États en matière de droits de l'homme. Et en faisant une étude analogique, nous tirons la conclusion que les conventions sur les changements climatiques, sur la corruption et sur les ressources naturelles, vous conviendrez avec nous bien sûr, ne prévoient pas expressément des droits aux individus et n'imposent pas non plus des obligations internationales aux États en matière de droits de l'homme.
Alors, sur le premier point, on peut vous suivre. Sur le second, c'est quelque peu plus discutable. Le fait que des obligations imposées aux États en matière de droits de l'homme, si on pense environnement et droits de l'homme, il y a des liens très très forts, par exemple, ou corruption et protection des droits de l'homme. Donc, il y aurait bien des obligations imposées aux États de lutter contre la corruption pour assurer une société plus démocratique et donc plus respectueuse des droits de l'homme. Vous voyez, il y a des liens que l'on peut faire.
Comme nous l'avons dit dans le paragraphe 57 de l'AR et APDHP contre la Côte d'Ivoire, il ressort clairement qu'il faut se fonder sur l'objet qui reconnaît expressément des droits aux individus ou encore impose des obligations internationales aux États. Et même dans l'affaire Arma Gueye contre la Côte d'Ivoire, la Cour africaine des droits de l'homme et des peuples a reconnu que la Convention de Vienne sur les relations consulaires est un instrument pertinent relatif aux droits de l'homme, mais a reconnu que dans cette convention, on peut tirer des droits de l'homme, mais en vertu de l'article 30, lettre B de la Convention de Vienne sur les relations diplomatiques, qui, si je peux me le permettre sans le dire express, qui impose aux États l'assistance consulaire. Et vous conviendrez avec nous que dans l'assistance consulaire, il n'est aucunement dit que les États ont une obligation de procès équitable. Il a fallu que la Cour se rabatte sur la charte pour pouvoir tirer une conclusion que la Convention de Vienne sur les relations diplomatiques est un instrument pertinent relatif aux droits de l'homme. Donc en cela, on ne peut pas se fonder sur un instrument qui ne reconnaît pas expressément. On se fonde toujours sur un instrument ou encore on fait un flashback sur la charte qui reconnaît expressément des instruments.
Where there are activities which seek to destroy the environment, should this court ignore as not having relevance for human rights?
Pouvez-vous reprendre s'il vous plaît? Je n'ai pas pu saisir le début.
Where you have activities such as you alluded to climate change, we are talking about illegal mining and all that, which destroy the environment. Should we ignore them as not being relevant to human rights?
La question est de savoir, dans des situations de changement climatique, de destruction de l'environnement, est-ce que cette Cour-là n'a pas la compétence de connaître de cette affaire?
Si je comprends bien, en cas de changement climatique, est-ce qu'on peut poursuivre un État devant votre obispo? Telle est la question.
Yes.
En matière de changement climatique, on ne peut pas poursuivre un État devant votre obispo parce que même les États qui se disent développés, je cite ici les États-Unis, la Grande-Bretagne, la Chine, ne sont même pas en reste pour ce qui est du changement climatique. Et si je ne me trompe, l'ouragan Katrina qui a fait des ravages aux États-Unis a causé des dégâts énormes. Et en cela, l'État est incapable. Et du moins, tous les États sont incapables en matière de changement climatique, quitte à se donner la main pour aller vers des conventions qui réglementeront cela. Comme nous l'avons relevé, votre Cour est matériellement incompétente pour ce qui est de allégations d'exploitation minière illégale et des faits de corruption. Secondo, votre cour est temporellement incompétente. Cette compétence, bien que n'étant pas prévue expressis verbis par le protocole de Ouagadougou, tire son essence soit de la jurisprudence, soit de la doctrine. Et dans l'affaire Commission africaine des droits de l'homme et des peuples contre la grande jamaïria arabe, libyenne, populaire et socialiste, entendue par là la Libye, il ressort que les dates clés à prendre en compte dans la détermination de la compétence temporelle de votre cour sont celles de l'entrée en vigueur de la charte et du protocole. Et au juge Fatsa Ougerbouz de nous préciser, dans son opinion individuelle, que la date critique à prendre en compte est celle du dépôt par l'État de la déclaration prévue à l'article 34.6 du protocole de Ouagadougou. Dans le cas d'espèce, des allégations de corruption se sont produites en 2017, paragraphe 17 du rapport factuel, et en 2018, paragraphe 12 du rapport factuel, soit 2 ans avant l'intervention de la déclaration prévue à l'article 34.6 de Ouagadougou. Il plaira donc à votre cour de partir du constat que des faits de corruption sont antérieurs à la déclaration facultative faite par Sensifia le 5 juillet 2019. Et en se fondant sur cela, votre cour est incompétente pour se prononcer sur ces allégations. Tout compte fait, concernant votre compétence, de vous convaincre d'une chose claire et limpide. Vous êtes incompétent tant sur le plan matériel que temporel. Nous aurions pu nous en limiter là, mais la requête est tout aussi évidente, irrecevable. Maintenant, nous soulevons les exceptions d'irrecevabilité. À l'aune de l'article 56 de la Charte, par renvoi de l'article 6.2 du protocole, contrairement à ce que avançaient nos confrères, la Charte africaine en son article 56 ne prévoit pas les conditions de recevabilité de la Cour, mais plutôt celles de la Commission. Il a fallu attendre le protocole de Ouagadougou pour pouvoir faire un renvoi à cet article 56 de la Charte. Il ressort de cet article que les voies de recours internes n'ont pas été épuisées. Premièrement, épuisées et la requête n'a pas été introduite dans un délai raisonnable. Premièrement, les voies de recours internes n'ont pas été épuisées pour ce qui est des points A, B et C du rapport factuel, alors que les voies de recours internes sont disponibles, suffisantes et satisfaisantes à l'aune de l'article 56, alinéa 6 de la Charte, par renvoi de l'article 6.2 du protocole de Ouagadougou. D'abord, les faits de corruption. Les investigations sont toujours en cours, mais justifiées par le fait que la corruption est une infraction complexe qui demande beaucoup de temps dans l'investigation. En effet, dans l'arrêt du 21 juin 2013, Norbert Zongo et autres contre le Burkina Faso, paragraphe 121, votre cour a estimé que ce qui constitue un retard injustifié doit être déterminé au cas par cas. Et toujours, votre cour d'ajouter, dans l'affaire William et autres contre la Tanzanie, qu'un retard est justiciable si l'affaire est visiblement complexe et difficile d'avancer dans les enquêtes. Le comité de l'Organisation des Nations Unies sur les drogues et la corruption, dans son rapport de 2004 sur la corruption, fait ressortir que les crimes les plus graves et les plus complexes, il ressort également la corruption. Monsieur le Président, honorable membre de la Cour, ces développements justifient ici à suffisance que la procédure d'enquête devant le BPS, au paragraphe 17 du rapport factuel, la partie requérante devait attendre que l'enquête soit bouclée avant de porter l'affaire devant votre cour. La requête est donc prématurée. Ensuite,
excusez-moi, maître. Dans l'analyse du délai raisonnable, vous prenez en compte la complexité de l'affaire, de façon pertinente. Est-ce qu'il n'y a pas d'autres éléments qui peuvent aussi rentrer en ligne de compte? Et si oui, lesquels, selon la jurisprudence tant de la Cour africaine peu des standards internationaux posés par d'autres tribunaux.
Ok, pour ce qui est de la raisonnabilité du délai, il existe d'autres exceptions. En cela, on cite l'affaire Alex Thomas contre Tanzanie, dans laquelle votre auguste cour a fait ressortir que la raisonnabilité du délai peut s'apprécier au regard de la qualité du requérant, à savoir soit que le requérant est un profane, détenu en prison, ou encore n'a pas connaissance de l'existence de la cour. Alors qu'en l'espèce, Madame la juge, l'ONG Gora, ici présente, au paragraphe 8 du rapport factuel, dans les dernières lignes, il ressort clairement que l'ONG Gora a une connaissance bien pétrée du système africain des droits de l'homme et a porté nombre d'affaires devant la commission.
En effet, j'ai bien vu votre travail. Mais quid de l'attitude des juridictions internes, qui elles aussi peuvent être à la base d'un délai irraisonnable? Est-ce que vos juridictions, les juridictions de votre État, ont traité dans un délai correct, sans opérer des formules dilatoires, le traitement de la corruption? Parce que dans l'analyse du délai raisonnable, il y a aussi l'analyse de la propre attitude des juridictions internes. Se sont-elles comportées, les juridictions de votre État, de façon rapide? Est-ce qu'elles ont traité correctement, rapidement l'affaire?
En l'espèce, il ressort que le délai raisonnable pour ce qui est devant la cour d'appel est de 2 ans. Or, en l'espèce, les 2 ans ne sont pas encore atteints. En conséquence, le fait que les requérants aient porté l'affaire, quand bien même le délai n'a pas encore été atteint, vous conviendrez avec nous que cela est prématuré.
In African Union, we have the Executive Council Against Corruption. Can you tell us if your states follow any recommendation of this Executive Council Against Corruption? Thank you.
S'il vous plaît, pouvez-vous reprendre?
Okay, I'm asking, according to the African system, we have an Executive Council Against Corruption. And my question is, do the states follow the recommendation of this council?
Merci pour la question. Effectivement, selon l'Union africaine, les États doivent assurer certaines garanties. En cela, premièrement, ceux qui se plaignent, les plaignants des faits de corruption, doivent être anonymes. En cela, la République de Saint-Sifia a mis en place une plateforme en ligne qui permet à ses citoyens de dénoncer anonymement les faits de corruption. Ensuite, à côté de cela, on ajoute le fait que, vu la gravité ou encore les conséquences de la corruption sur l'économie de Saint-Sifia, cet État a mis en place le bureau du procureur spécial, à l'exemple du Ghana, pour lutter efficacement contre les faits de corruption. Donc, en cela, monsieur le juge, vous conviendrez avec nous, bien sûr, que Saint-Sifia a mis en place tout ce qui est de son pouvoir pour lutter efficacement contre les faits de corruption.
Your time is up, but because of the translation, I'm adding 1 more minute to enable my colleague to the right to ask you a question.
Thank you, Judge. My question is, it is necessary to be expressively in the treaties that the object with regards to human rights, for instance, when there is a situation where for instance, in this case, for the mining, look for the fact that the mining activity was causing harmful to the environment and to the people, can we not infer from this court with regards to material jurisdiction, that we have jurisdiction to attend this matter as long as the issue that comes from those treaties and conventions affects the human rights? I want to hear about that.
Thank you for the question. We invoke the Nobet Zongo case versus Burkina Faso, where it is stipulated that your court makes a distinction between what is instantaneous violation and continuous violation by basing Article 14, that the CDI article on the internal responsibilities, international responsibilities of the government of the state, which the 2001 Article 14, that you should make a difference between instantaneous violation and then where the human right happened, and we should not confuse this with other violations, though the instantaneous violation can have effect in the future, and we should not confuse this with continuous violations. Just as it is in the case of Burkina Faso, Nové Zongo versus Burkina Faso, as provided in Article 14, the provisions of the UN on environment, which talked about damages, do not fall within the temporal jurisdiction of your court.
Your time is up. Your time is up, so yield to your colleague.
Merci, Monsieur le Président. Je cède le plaidoir à Daniel Macour.
Yes, proceed.
Presiding Judge, Your Excellencies, recognizing all the languages represented in this dispute, allow me to say good morning, bonjour, hola, and assalamu alaikum. My name is Daniel Morakaru, and I will be addressing this honorable court on merit A with regards to holding Mr. Putin and Mr. Nsana accountable. At the very onset, members of the bench, we would like to disagree with the arguments made by the applicants.
Excuse me, let's hear your name well. Is it, say your name again?
Presiding Judge, my name is Daniel Morakaru.
All right, proceed.
Thank you, Presiding Judge. At the very onset, we, as the respondents, would like to disagree with the applicant's submissions that we violated the Charter and other international human rights norms with regards to how we held Mr. Putin and Mr. Nsana accountable. We shall show to this particular court that we indeed met our obligations as enshrined in the Charter. We shall do this in two ways. First, with regards to Mr. Putin, and second, with regards to Mr. Nsana. Turning to the first limb on Mr. Putin, it is an undeniable truth that illegal mining has been taking place in Sensifia. However, we as the respondents submit that we have not been silent and have taken action towards curbing the illegal mining. Your Excellencies, Article 24 of the African Charter provides for the right to an environment conducive for development. Furthermore, the African Commission, in the 2001 decision of Sirac versus Nigeria, particularly in paragraph 52, mandates states to ensure that they punish those people who destroy the environment. Your Excellencies, as can be seen in paragraph 13 of the fact sheet, the Sensifians Minerals Commission conducted a night raid. And during that night raid, they were able to arrest 50 Camelotian nationals who were conducting illegal mining on unlicensed concessionary lands. Thereafter, the Republic of Sensifia arrested Mr. Putin, who is the legal owner of Adrix Limited and Angold PLC. Your Excellencies, in the spirit of cooperation as enshrined in Article 3K of the African Act, of the African Union Constitutive Act, the Republic of Sensifia decided to extradite Mr. Putin to the Republic of Camelot. Your Excellencies, this decision to extradite was based on the following circumstances. First, the Republic of Camelot promised that Mr. Putin would get a heavier punishment of 15 years as compared to what we had in Sensifia, that is 3 years imprisonment.
But agent, you've already said that where the environment is being destroyed, the state is obligated to punish. Now, where you have extradited Mr. Putin to Camelot, he's convicted and in no time he's pardoned. Has the state of the respondent, has it actually lived up to its obligation to punish those who destroy the environment?
Much obliged, Your Excellencies. And in answering your question, we would like to submit that first, Mr. Putin was a Camelotian national, and therefore, according to public international law, both the Republic of Camelot and the Republic of Sensifia had the right to either prosecute him. And it is in that regard, Your Excellencies, that we decided to extradite Mr. Putin to the Republic of Camelot based on the following circumstances. That first, he would get a heavier sentence of 15 years imprisonment. And second, the fact that the people of Akan were going to get a compensation package of $7 million US.
Sorry to interfere. In the mic system, it said that if you are too close to it, it gives a bad feedback. So if you can create a bit of distance. Thank you.
Much obliged, Your Excellencies. Proceeding to our arguments, the applicants have raised two main issues. That first, we did not prosecute Mr. Putin, and secondly, that we failed to compensate the people of Akan. However, Your Excellencies, we have demonstrated to this court that we held Mr. Putin accountable by extraditing him to the Republic of Camelot, where he was prosecuted and later served a sentence of 2 years and 4 months. Your Excellencies, to that extent, we consider that we performed our obligation with regards to punishing Mr. Putin. On to the second limb, with regards to the failure to compensate. Your Excellencies, the people of Akan, who are the victims in this particular case, were compensated in two ways. First, through the extradition agreement, the Republic of Camelot promised to pay them $7 million US. And secondly, the Sensifian courts have awarded the people of Sensifia $3.5 million US. However, Your Excellencies, we would like to submit that we have not yet realized the compensation with regards to the people of Akan. And this is why. Your Excellencies, there is a difference in time with regards to the time that this matter has been brought before this court and the time that we agreed to compensate the people of Akan. Your Excellencies, we were facing the economic situations, the harsh economic situations that were brought about by COVID-19. And Your Excellencies, we ask you to draw inspiration from the International Law Commission's draft articles on the responsibility of states against wrongful acts, particularly Article 25, which states that states can be precluded from wrongful acts on the ground of necessity, so long as it is to protect an essential interest against an imminent peril. Your Excellencies, we submit that at that particular moment, we could not be able to give the people of Akan the $3.5 million US. However, Your Excellencies,
Agent, before you move on, you cited the ILC draft article on state responsibility.
yes,
What is this status in international law and before this court?
Your Excellencies, the status of the ILC draft commission articles is part of customary law of international law, since according to the statute of the ILC, statute of the International Law Commission, the commission is mandated to draft articles. I beg your pardon, it is mandated to ensure that it drafts the state practices with regards to international law. Furthermore, Your Excellencies, Article 60 of the African Charter asked this court to draw inspiration from...
Before this case, is there any jurisprudence from the African Court or Commission in which the ILC draft articles on state responsibility has been relied upon?
Your Excellencies, we unfortunately do not have any decision whereby the court has relied on the ILC draft articles. However, we are persuasively asking this particular court to consider the draft articles while it retires to make its judgments. Your Excellencies.
Yeah, proceed.
Thank you, Your Excellencies. Proceeding to the matter on compensation, we were submitting that we have not been able to compensate financially the people of Akan. However, as can be seen in paragraph 14 of the fact sheet, we have gone ahead to provide for them temporary shelters and also acquire new lands where we are going to relocate them. Your Excellencies, we therefore submit that we have done all we can to ensure that we protect and we punish Mr. Putin for illegal mining. Your Excellencies, if there are no questions, I will proceed to my second limb on Mr. Nsana.
Proceed.
Moving on to the second limb on Mr. Nsana, the applicants have submitted that we failed to hold Mr. Nsana accountable for corruption. However, before we address that, we would like to highlight to this court the various measures that we have taken according to our obligation in the African Union Convention on Preventing and Combating Corruption, hereinafter referred to as the Convention on Corruption. Firstly, according to Article 5.1 of the Convention on Corruption, Sensivia has established corruption offenses under Section 175 of Sensivia's Criminal Code. Secondly, according to Article 5.5 of the African Convention on Combating Corruption, Sensivia has put in place an anonymous reporting system which allows witnesses to report corruption allegations without any fear. And thirdly, according to Article 5.6 of the Convention on Combating Corruption, we have gone ahead to establish anti-corruption institutions which are mandated to investigate corruption matters in Sensivia. Your Excellencies, the main issue with regards to holding Mr. Nsana accountable raises from the fact that we have not conducted investigations. However, Your Excellencies, in discharging the obligation to investigate, the African Commission in Zimbabwe NGO Forum versus Zimbabwe, particularly in paragraph 158, stated that this court should consider the effort in which the state has taken towards conducting those investigations. Your Excellencies, we submit that the Republic of Sensivia has exerted effort towards ensuring that it conducts investigations against Mr. Nsana.
Is it not worrying that a very special Office of Special Prosecutor, set up to deal with the corruption, simply abdicated its responsibility when the Commission on the Human Rights came to the conclusion that there was no case for corruption?
Your Excellencies, we indeed recognize that the Office of the Special Prosecution decided not to conduct or open any further investigations after the Commission on Human Rights and Administrative Justice stated that Mr. Nsana was not corrupt. However, Your Excellencies, A reading of paragraph 17 of the fact sheet shows us that the Attorney General of the Republic of Sensifia approached the High Court and asked the court to ask the Office of the Special Prosecution to open extra investigations against Mr. Nsana. Your Excellencies, we submit that these investigations are still ongoing as the witnesses in this particular case did not leave any contacts or any evidence to buttress the allegations. We submit that the 2 years delay is justifiable because the Office of the Special Prosecution is taking its time towards identifying who are the witnesses and what is the evidence that they had.
But agent, is it not the case that the Office of Special Prosecution is already prejudiced, having already come to conclusion that agreeing with the Commission for Human Rights, there's no corruption? The High Court questions it, and then it says that I'm going to investigate that which I've already concluded there's no corruption.
Your Excellencies, we beg to disagree that the Office of the Special Prosecution is biased. Your Excellencies, it is not biased as it is an independent organization that is established in the Republic of Sensifia according to the Office of the Special Prosecution Act. Your Excellencies, seeing that my time is far much spent, I would like to ask this court to graciously allocate me 1 more minute.
30 seconds.
Much obliged, Your Excellencies. It is in that regard that we submit that we did not violate the Charter or any other international human rights norms in our handling of the claims against Mr. Nsana, as we have exerted numerous efforts towards ensuring that we investigate him. Your Excellencies, thank you so much for your time, and I will now yield the floor to my co-counsel, Ms. Martha Jepkemei. Yes.
Yes, take
Just the last observation. In your submissions, allegation A, you wrote Mr. Putin with U, P-U-T-I-N. And after that, you wrote Mr. Putin with P-O-U. Which one are we talking about?
Your Excellencies, thank you for that question. That was, apologies for that.
Be careful with your response.
Your Excellencies, in responding to that, we apologize for that small clerical error.
It's okay.
Yeah, we were referring to Mr. Putin with the U. Thank you so much.
Not that one.
Not the other one with the
Okay.
O. Thank you so much, Your Excellencies. Have a lovely afternoon.
All right.
Once again, Judge President, Your Excellencies, good afternoon. My name is Martha Jepkemei, appearing as the third counsel for the respondents. I will address 2 issues, Merit B and Merit C, that is on the treatment of the children and Gora senior staff member at the villa, and thereafter I shall proceed to canvass the free senior high school policy. Having carefully listened to the applicant's pleading on 2 issues, we draw one conclusion, and that is, these 2 issues have one thing in common. They both entail the applicant's dissatisfaction with the respondent's reaction to COVID-19 and economic recession in Sensifia. This notwithstanding, what we would like to point out to this court at the very onset is that neither the right argued under Merit B nor those argued under Merit C are inherently absolute. They are either subject to limitation or subject to progressive realization. With this in mind, Your Excellencies, I'll proceed to our submission on Merit B. The applicants made their pleadings in 2 limbs. That first, the measures we adopted violated the best interest of the child principle, as well as the right to liberty of the Gora senior staff members. Members of the bench, I'll proceed to address the violation of the right to liberty. It is our submission that the detention in question is administrative detention and not the detention that is based on criminal matters. The difference, Your Excellencies, is that administrative detention is made via the President Directive, which can be seen in paragraph 19 of the facts. Allow me to rely to General Comment number 8 on the right to liberty and security of persons as enshrined in Article 9 of the ICCPR, where the Human Rights Committee rightly noted that when it comes to administrative detention, Article 9.1 and 9.4 are only applicable in that matter. And therefore, Your Excellencies, Article 9.2 of the ICCPR, as well as Article 9.3, is not applicable. And that is with regards to taking the members that are detained to judicial members of the bench for criminal trials. It is on that basis that we submit that the submission by the applicant.
But agent, if we are to go by your submission that was administrative detention, how do you justify the very high walls and then the armed guards?
Indeed, Your Excellencies, in response to the submission of very high walls and armed guards, our position is that the detention first detention was meant to curb the spread of COVID-19, but curtailing unregulated movement. The presence of armed guards, as can be seen in paragraph 19 of the fact, was to prevent anyone from moving out of the place that they were, that is the villa. Your Excellencies, the difference in the detention is not meant on the where these people are being placed, but rather the manner of implementation. I'll proceed to submit that the deprivation of liberty was not arbitrary. This is because it was a justifiable limitation that adhered to the limitation test set out by this court at paragraph 135 of Umuhoza versus Rwanda. That is, a limitation that is prescribed by the law that was necessary and proportionate to the legitimate aim pursued.
What were the facts of that case? What happened in that case, the authority that we just started?
Members of the bench, while the facts of Umuhoza versus Rwanda was with regard to the freedom of expression and the matters of genocide in Rwanda, the limitation set out by this court is applicable because it has been applied in all instances, and we may say that it adheres to in all cases of limitation of rights. With regards to legality, Your Excellencies, it is not in contention that the detention of the children and Gora senior staff members was prescribed by our law, and that is the Imposition of Restriction Act that gave the President the authority to adopt directives that restrict on various light on purposes of public health. What is contention before this court is the proportionality of the detention.
Can a state vaccinate without the consent of parents or children?
Kindly pardon me, Your Excellency.
Even in pandemic situation, can a state vaccinate children without the consent of parents?
Much obliged to answer your question. With regards to vaccination of the children, indeed, the state can adopt compulsory vaccination. Relying on the WHO policy brief that was released in May 2020, the WHO indeed appreciated that states can adopt compulsory vaccination. And in accordance to the submission made by the applicant, they submitted this vaccination as possible. Therefore, members of the bench, I'll proceed to differentiate the two. The vaccination in question was compulsory and not forcible. The difference is compulsory vaccination is allowed in law, while forcible vaccination is not. In the European Court of Human Rights, in the 2021 decision of Fabrica versus Czech Republic, the court proceeded to describe compulsory vaccination as a vaccination system that is made mandatory for everyone in the state for purposes of public health concerns. And in order to ensure compliance with this policy, the states are allowed to adopt restrictions, such as restrictions to the access of public services, or what happened in the case, restriction on movement. Your Excellencies, however, for forcible vaccination, it tends to be more diabolical. This can be seen from the Human Rights Watch report on what happened in China. In China, Your Excellencies, the police officer would barge in the people's house and take them to the vaccination center forcefully. We don't see any of that happening in the state of Sensitia. What we see is the respondent following the dictates of the European Court of Human Rights, restrict their rights until they accept. With regards to children, Your Excellencies, it is our submission that according to the UNICEF minimum guideline on consent, children lack capacity to consent. And therefore, members of the bench, this responsibility is bestowed
Is
on the
that position absolute? Especially if you have the regards to municipal decision in the United Kingdom, like the well-known case of the 15-year-old child who was given contraceptive advice without the involvement of the parents and what they both say. Is it absolute that the children, at all circumstances, can never give consent? The Gaelic, I'm talking about the Gaelic against the Norfolk and the West Bench Health Authority case.
I do not share concern, Your Excellency. As it stands for now, indeed, children lack capacity to consent. And what they're allowed to do, Your Excellency, is to express their opinion. Allow me to finish up on the consent and then address expression. With regards to consent, Your Excellencies, the responsibility to give consent on medical matters is bestowed on the parents pursuant to Article 18 of the United Nations Convention on the Rights of the Child. However, Your Excellency, as can be seen in paragraph 19 of the FAQ, the children in question are unaccompanied. And with regards to unaccompanied children, General Comment number 6 on the treatment of unaccompanied children at paragraph 2 defines unaccompanied children to be children who are not, they don't have parents or others to take care of them. And therefore this responsibility transfers to the state. It was on that basis that our state, the state of St. Cecilia, vaccinated the children. With regards to expression, members of the
No,
bench,
but before that, there's a consent that having vaccinated them, you took them to the street and just left them there. Especially so when there was a public health crisis.
members of the bench, I'll answer your question in two ways. That first, the public crisis had ceased at the moment. This is because, as can be seen in paragraph 22 of the FAQ, we uplifted all the COVID-related bans and imposed compulsory vaccination. This was meant to ensure the return of the life of the Cecipians to normalcy. With regards to the issue of returning children back to the streets, it is our concession that indeed that's a bad fact on the side of the respondent states. However, a keen look at what the applicant brought us before the court today is with regards to the treatment of the children in the villa. And that can be seen from paragraph 19. We accommodated them, catered for them, and took care of them. Members of the bench, it is right to conclude that in these 6 months, the children were able to get better care than what they have achieved in the life at the streets. Proceeding to our argument, Your Excellencies, I'll proceed to address the proportionality of the detention. This court, in the case of Mtikila versus Tanzania, at paragraph 106, stated that a limitation is proportionate if it strikes a fair balance between the legitimate aim pursued and the harm to the right in question. And a fair balance is considered to be struck when the benefit of protecting the interest outweighs the harm to the right in question. Members of the bench, let us weigh and balance these two and see which carries the day. In terms of the harm suffered, indeed, the Gorasime staff members were not able to move at their will because they were constrained within the villa for 6 months. However, in terms of the benefit, the state was able to deter others from violating the president's directive, therefore being able to keep COVID-19 at the minimum. Secondly, members of the bench, it is our submission by the time that we were releasing them, we were able to vaccinate them, and therefore their immune system was boosted and a creation of 93% defense against the virus. It is our submission that the measures were proportionate and therefore we did not violate the right to liberty. Allow me to address shortly the best interest of the child principle in accordance to the pleadings made by the applicant. The applicant submitted that by putting the children at the villa, we violated their rights. It is our submission, Your Excellencies, as initially stated, this was in their best interest. The applicant gave this court as an alternative that perhaps he could have taken these children to a more suitable institution. However, it is our submission that could be riskier to other children. Remember, members of the bench, that this time is when COVID-19 was at its peak. And when we took the children, we could not in certainty say whether they were affected or not. By taking them to other charitable children institution, members of the bench, will be a riskier method to other children living there, and therefore we could not do that.
So you are saying that it justifies the trauma which the children were subjected to, having regard to the horrifying state of the facility in which they were placed?
Not at all. We can never justify trauma on children. Members of the bench, these children did not suffer any trauma. Allow me to rely on Article 37C. We agree that we deprived these children of their liberty, and we proceeded to put them together with the adults. However, Rule 29 of the United Nations Rules on Protection of Children Deprived of Liberty states that under controlled conditions, children can be placed together with carefully selected adults, as it has proven to be a special program that enhances holistic development of children. May I remind this court that the Gora senior staff members were not hardened criminals. They were human rights activists, and being together with the children, it creates a safe environment for the children. Your Excellencies, it is our submission, therefore, that the treatment of the children and Gora senior staff members was in the best interest of the children and did not violate the right to liberty for the Gora senior staff members. Therefore, members of the bench, I'll proceed to converse on merit claim 6. Regarding the free senior high school policy, the bone of contention is that we limited the scope of coverage of the free senior high school policy from covering 6,000 plus schools to only 150 schools. We agree, Your Excellencies, that even at face value, that's a retrogressive measure. However, principle number 20 of the African Commission Principles on the implementation of economic, social, and cultural rights provided in the African Charter allows states to take retrogressive measures and by following particular guidelines. This guideline, Your Excellencies, provides that 1, the state must have carefully considered all the available alternatives. Secondly, the decision must be made in the context of the full use of maximum available resources. Members of the bench, we did all of this. Allow me to guide you to paragraph 21 of the facts. By the advice of the EMT, first, we increased export and import duties. We proceeded to increase the corporate taxes, further implemented the e-levy policy. However, it was so unfortunate that the only generatable revenue was 4%. The pooled revenue could not mitigate the economic situation of St. Cecilia, and it was at that time that the president decided to cut the finance of other government-sponsored policy, including the free senior high school policy. Secondly, Your Excellencies, regarding the maximum available resource, allow me to guide you to paragraph 1 of the fact.
But before that, we are also told that there are plants which are immune boosters, and you could have resorted to that so that you get resources to continue with the free SHS policy.
Members of the bench, I indeed had the alternative offered by the state of the applicants, and that is using the Huguenot trees. And as can be seen in paragraph 2 of the fact, the state of St. Cecilia is a state that values culture, and an instance of that culture is the highly valued Huguenot tree. By suggesting that we could have used Huguenot trees, Your Excellencies, is equally saying that we should have forced deforestation of places where we have these Huguenot trees, and therefore even proceed to violate the right of culture for the people of St. Cecilia. This is because, Your Excellencies, COVID-19 is a world pandemic. It's not just affecting a state or a particular place in St. Cecilia. It is affecting the whole country. How many Huguenot trees will we need in order to come up with enough vaccines? Secondly, Your Excellency, we did not have the luxury of time and finance to extract these products from the Huguenot tree. It is therefore our submission that the alternative offered by the applicant is not applicable in this particular instance. Proceeding to the second limb of the argument on the use of maximum available resources, paragraph 1 of the Facts provides that St. is a lower middle income country, and we majorly rely on foreign investment. According to paragraph 18 of the Facts, foreign investment profits have reduced by 56%. And at this point, Your Excellency, paragraph 21 of the Facts shows that the investors are clearly running away from our state. We basically had little to no money to support the FFHI's policy. It is therefore our submission that the retrogressive measure was justifiable. Regarding the act of discrimination, Your Excellencies, Committee on Economic, Social and Cultural Rights, in General Comment number 3 on nature of the state obligation, at paragraph 12, states that even in time of resource constraint, the state must make sure to provide for the vulnerable members of our society. Paragraph 1 of the Fact shows the social stratification in St. Lucia. We have the westernized and wealthy persons in the 16 regions of St. Lucia, and we have the marginal income earners at 160 district assemblies, the 150 schools. Members of the bench, may you kindly graciously add me 30 seconds to conclude.
Proceed, 30 seconds.
Thank you for your grace. Regarding the issue of social stratification in St. Peter, we have the wealthy, westernized members in the 16 regions of the state. And we have the marginal income earners in the 160 district assembly. And as can be seen in paragraph 21 of the Fact, the president rightfully stated that the 150 less endowed schools were picked from various rural areas in St. Lucia. Therefore, Your Excellency, the criterion that we used was more of vulnerability of the members of our society with regard.
Right. Time up. Thank you.
Thank you, members of the bench.
Honorable juge.
Honorable judges, my name is Chentole Abdul Rashid. I'm going to speak. So I'm going to talk about the sexual minorities. But before we come to that, I want to correct some allegations. So the adage says that, so if lions do not have their own hunters will continue talking about their own story. The respondent says that the children were detained in the prison. It is of bad faith in paragraph 19 of the factual report that the children were kept in a villa and they were fed. So the case here was deformed. The second issue is that what is the relevance of the Committee of Human Rights in your court? The respondents mentioned Article 57 instead of Article 60 of the Charter, which says that the
Said the respondent said, but you are respondent.
Je voulais dire, honorable juge, la partie requérante.
So, I want to say the petitioner. So, I mentioned the committee, and I want to say that the charter said that the court takes into account so now I want to talk about the sexual minorities and my laws. I want to say that Saint-Ifia has not violated human rights by refusing to register the sexual minorities. I base my argument on the African Charter and then the conception of what African countries think about this. Saint-Ifia is not a state that oppresses LGBTQ. On the contrary, it shows a certain tolerance towards them. So these LGBT people are free to express themselves, to associate themselves. Aisha organize during these recent years public conferences and also made communication on her Twitter platforms. They also have a permanent office, and the director has obtained a permanent office in Asida, and this director has been able to sponsor TV advert on the main TV channels in Sentifia. So Sentifia does not have any problem with regard to the right of LGBT people. The refusal, the CDM's refusal to register is not a violation of the right of minorities. My lords, I want to say that our society is not yet open on the issue of gender identity and gender orientation. Look at the reactions of religious leaders as well as the reaction of chieftaincy.
But agents, we have been referred to letter of examples from the African continent in which,
Okay, good. No translation that
we have been referred to letter of examples on the African continent in which states have recognized right of sexual minorities. And the facts even give examples per the advert that the transgender ran. So it's not alien to the African human rights systems.
It's okay. Honorable Juge.
My lord, thank you for the question. Indeed, we have countries in Africa that have recognized minority rights. For example, South Africa that has recognized marriage. This is an isolated case because most African cases, as we are going to demonstrate it further, are against these practices. Thank you. Does our court take into account African? Is it important for us whether majority or minorities recognize the right of this minority people? Yeah, this is your argument. The existence of the majority of Africans are against it. So, is this necessary for our court to statute on this case? So, does it validate the status quo? So, I want to allow you to answer this. Honorable judges, your court was created by African states who signed the instrument that created it. And we think that the court must take into account the general will of the state. The general will of the state is discriminatory. My lord, if you think that this is not relevant, we want to add other argument to convince you. So the refusal for this, so the refusal is explained by the desire to preserve traditional values as required by Article 17.3 of the Charter, which makes the promotion and protection of traditional values recognized by the community a duty of the state. For example, admittedly, neither the Charter, the Commission, nor the Court defines what is meant by traditional values. But in view of the heterogeneity of African societies and cultures, the Court should leave a national margin of appreciation to each state in determining these traditional values. Moreover, the Kambole state according to so the African Charter said that when there's no convergence on the state, we should allow the state to to to, to judge a case taking into account their own realities. So in 2020,
Is that not too dangerous if we are to allow margin of appreciation to states regarding what amounts to traditional values? A lot of states will be taking advantage of that to violate so many other human rights of life obligations.
I'm sorry, I didn't get this question. If you can please.
I would like to know.
No, sorry, I mean in French because I didn't get it.
Yes, so if the states are
French,
given
please,
the opportunity to determine what amounts to traditional.
Honorable Judge, no translation, and I need a question in French
Yes,
because I'm not getting it.
you can put it. Yes. Yeah, so if the state is allowed to determine what amounts to traditional values, is that not too much of a window to enable the state to violate a lot of human rights human rights obligations in the name of traditional values?
Honorable Juge,
Okay.
I got it. Yes, thank you.
honorable judges, the fact that to work with the state on traditional values is not a window for the violation of human rights, but as we said, Saint-Fia did not violate the right of the minorities, but it protected them and also to ensure and promote the traditional values. And I do not see here the violation of human rights. They have the right to express themselves, to associate themselves, and these rights were not violated in any way. Honorable judges, as we said in the Kambole versus Tanzania, you refer to the European Commission of Human Rights, and you agree that the issue of national margin was relevant. So with regard to this national margin for each state, as we said here, the court must not act as a prosecutor and allow each state to decide. So for them to determine whether it is a traditional value or they have to define what they mean. But traditional value and Saint-Fia want to protect these traditional values. Between the protection of these traditional values, yes. So which is which? I did not understand the question. You want to demonstrate so no minority right is violated by forbidding them to defend themselves. Because we do not allow them to defend their right with the registration of the association. Is it not discriminatory with regard to the rest of the community? But you are discriminating them based on traditional values. If you want your God, you want us to value traditional value with respect to the cardinal value of international law, will you continue defending the case this way? Honorable Court, you have the principle of non-discriminatory, but we will continue in this sense because the African court itself went in this court, and this is what we're going to demonstrate right now. At the beginning, the African Commission during the 73rd ordinary session, rejected the applications of 3 organizations on the grounds that sexual orientation is not a right expressly recognized by the Charter and that it is contrary to the virtues of African values. So this is the same reason for the rejection of Centifia's application to register the CDMS. Centifia is a state that respects human rights. But looking at the current issue, the future issues.
The agent, if you look at the constitution of Santifia, the provision on human rights, they have cited a provision which suggests that the human rights which the citizens are entitled to enjoy, I'm referring to Article 33 clause 5, are not limited to the human rights that have been spelled out in the Bill of Rights, but any human right and freedom considered to be inherent in democracy are also to be enjoyed. An applicant cited examples from the European human rights system and their jurisprudence to ground the argument that the right to sexual orientation is also recognized in some democracies. What is your take on that?
On the issue, to know that the Constitution is open to the respect of human rights as evoked by other international instruments, the Constitution does not deny the rights as enshrined in other international instruments. But as we have said, that now we have violated the human rights. Honorable judges, the court needs more evidence. According to UNESCO 2014, 33 countries in Africa criminalize homosexuals' actions. Most of these countries that adopted the African Charter, with the adoption of the Ouagadougou Charter, said that. So the issue, that is the issue of concession, that refusal to register them is not a violation or in contravention of human rights. So please, can you give me 30 seconds to finish?
30 seconds.
Thank you so much. Honorable juge, dans l'esprit qui anime cette délégation, malgré sa diversité linguistique, nous amène à solliciter à ce que les honorables juges que vous êtes retirent leur casque de traduction afin que l'on finisse nos observations orales avec un dernier mot en anglais et traduit en français. Please.
To speak
Your
English.
Excellencies,
I want to speak English now. Yeah.
we ask you, right, to scrutinize the respondent actions, not with skepticism, but with the recognition of their earnest intent to preserve and champion the well-being of the people of Sensifia. As you, with these decisions, remember that justice does not reside solely in statutes, but also in fulfillment of responsibilities. Responsibilities to those whose futures we hold in our hands. Translated in French, plaise à votre auguste cénacle d'examiner les actes.
We therefore pray this honorable court to recognize that the refusal to register the CDMS does not constitute a breach of the Charter, but, on the contrary, a preservation of traditional African values set out in the same Charter.
Thank you so much.
Thank you. There's a last question.
All right.
The last question. Okay, let me come back to one of the questions raised by our president about... en français, ok.
Yeah, better.
Ok. Donc, laissez-moi revenir sur une question.
So let me come to a question that was asked by our president with regard to tradition. So by the fact that if we have to take into account the tradition of each state, and you said in the case versus Mali, that the state of Mali violated the law by the fact that men and women were not equal with regard to legacy. And also, when a girl was supposed to get married at a reasonable age of 18, if we have to take tradition into account, the Malian state with the Islamists, when they wanted to change the law, there were a lot of manifestations, and they were not able to change the law, and therefore the girl was to get married around, let's say, 14 years. In this case, do you still think that we should take into account each tradition? Is there not going to be any discrimination at the state level? Because this may, or are you saying that in one breath we should allow other states, or on the other breath we should allow them to also come with their own laws? Honorable judges, we insist and we persist. So the appreciation margin that your court even evoked 3 years ago by being inspired by the European law. So if your court agree, why should we then be against it? So when the court took the decision to impose that a man and woman should be equal in terms of legacy, and that the woman should not get married before 18, and then at the meeting of head of state, they said when the government or the state took that decision, they can impose it on the Islamists. So do you think that we should allow the state to act? Yes, we insist, we persist, we are here to defend the state. We are saying and we maintain this issue. Thank you very much.
Your Excellencies, the applicant makes 5 points of rebuttal. First, the respondents have argued that the court does not have material jurisdiction over the UN Convention of Climate Change. However, you have held, in the case of APDF versus Mali, that the courts would have material jurisdiction where the obligations under that treaty give rise to the protection of human rights. It is our argument that the UN Convention of Climate Change give rise to obligations which further protect the rights to satisfactory environment under Article 24 of the African Charter. And consequently, this court has material jurisdiction.
Sorry, is that Bando or Anand?
Bando.
Right.
And consequently, this court has material jurisdiction. Second, Your Excellencies, the respondents have argued that the mere fact that the corruption violations occurred before depositing the optional declaration, the court does not have temporal jurisdiction. Your Excellencies, this is not the case. This court has held, in the case of Kijiji Isiaga versus Tanzania, that the court would still retain temporal jurisdiction where the violations are continuous in nature. And it is our submission that even though the corruption began before the respondent state deposited its optional declaration, its effects were still subsisting after the depositing of the optional declaration, and therefore this court has the continuous violation to hear the matter, contrary to what the applicant is making the court to believe.
By agent, respondent talk about instant violation vis-a-vis continuous violation. What is your reaction to that?
Your Excellencies, instantaneous violations, according to Nobezongo versus Burkina Faso, are those violations which occur finitely and therefore do not subsist after the state deposits its optional declaration. However, Your Excellencies, evidently from paragraph 14 and 13 of the facts, the illegal mining and corruption were still occurring after the respondent state deposited the optional declaration in 2019, and even to the extent that the respondent state has not remedied any of these violations, its effects are still subsisting, and therefore this court has the temporal jurisdiction to hear the matter. Third, Your Excellencies, the respondents have invoked the defense of necessity to justify their delay in paying compensation. However, Your Excellencies, for a state to invoke the defense of necessity under Article 25 of the ILC draft articles, it must be the only means to safeguard a state's essential security interests. And it is our submission that the state had other means to pay this compensation. Your Excellencies, the respondent state could have, based on Mr. Putin's conviction, and instituted a civil action in Centefia to pierce the veil of the Adrix Limited to liquidate their assets of the company and use that to pay the compensation of the victims.
But agent, the doctrine of piercing the veil or lifting the veil, is it of universal applicability? There's no evidence that is applicable to the municipal law of Santa Fe.
Your Excellencies, admittedly, it is not of universal applicability. However, it is mostly applicable in common law jurisdictions. And since from paragraph 1 of the fact and paragraph 4 of the fact, the respondent state is a common law jurisdiction, then it is our submission that the piercing of the veil principle would still apply to Centefia. Fourth, Your Excellencies, the respondents have argued that the detention of the 20 GORA senior members was an administrative detention. However, Your Excellencies, even with administrative detentions, according to the UN Human Rights Committee General Comment number 35, specifically at paragraph 15, the states must still comply with the guarantees under Article 9. It is therefore our submission that for failing to still comply with the guarantees under Article 9, the state has still violated the GORA members' rights. Finally, Your Excellencies, the respondent states have invoked the margin of appreciation to justify their discrimination against the 20 GORA senior members. However, Your Excellencies, the African Commission in Prince versus South Africa has noted that inasmuch as the state has this discretion, it is not absolute, and the court has the jurisdiction to review the steps taken by the state, provided that they are inconsistent with the state's international obligations.
Sorry, President, I would like to know to what extent can you demonstrate to this that this right can be limited in terms of mass appreciation? We know that this right is not absolute, but in facts, looking at the facts, how can you demonstrate and show this court that the state is hiding behind the margin of appreciation to not pass the legislation? It do not pass the statute of the
Your Excellencies, if you could rephrase the question, agent did not understand.
When you were talking, you said that the right margin of appreciation is not absolute right, has a limitation. So my question is, based on the facts on the case, how can you demonstrate to this court that the state, despite the fact there's a mass of appreciation, the state can still, there's no argument that the state can use the tradition because it's not absolute? Looking at the facts, can you show us in the fact?
Your Excellency, is it your question that from the facts, could the state have ensured the enjoyment of this right without having to violate its values?
No. If you look at the facts, can you point us to evidence to suggest that under no circumstance should the state rely on traditional values to escape its human rights obligation, having regard to the peculiar circumstances of this case.
Your Excellencies, the facts do not indicate so. However, the African Commission's decision indicates that the state cannot use its margin of appreciation to merely limit the rights where it is not justified. And Your Excellencies, it is our submission that the respondent state could have simply harmonized its values with its greater international obligation to protect the rights under the African Charter. They could have simply registered this organization and probably placed fetters on the kind of information that they put out so as to protect their values, at the same time respecting the freedom of association of these CSMR members. It is on these grounds that we submit that the refusal was unjustified by failing to explore this option. The applicants therefore praise this court to grant all the reliefs prayed and reparations. Respectfully submitted.
So the bench will recess briefly to deliberate, and then we'll come back.